Good morning and welcome to the Senate Committee on Commerce and Labor. Madam Secretary, please call the roll.
Senator Daly? Here. Senator Ellison? Present. Senator Flores?
Present.
Senator Lang? Here. Senator Rogish? Here. Senator Scheibel? Senator Steinbeck? Here. Chair Pazina?
Present. Thank you so much, and please mark Senator Scheibel absent excused. And with that, we do have a quorum, and we welcome our members as well as our audience here in Carson City, those that are joining us in Las Vegas, as well as those that are following along online. Before we begin, I'd like to go over just a few housekeeping items. First, I'd like to remind everyone to silence all of your electronic devices while in the committee room. Members of the public may provide testimony in various ways, all of which are listed on the agenda. You may also submit public comment in writing, either in addition to testifying or in the place of testifying. And if you wish to testify in person, please sign in at the table by the door and provide your business card to our fabulous committee secretary. When testifying in person, please turn the microphones on to speak and off to listen, as we have those that are following along in Las Vegas as well as online. And please remember to state and spell your name for the record. Anyone who'd like to receive electronic notifications of scheduled bills and access to the committee's meeting materials may do so by signing up on Nellis on the legislative website. Also note that committee members will be using our laptops to view handouts as well as other exhibits, so please don't view this as a sign of disrespect or inattention. And with that, we are going to move to our first item on the agenda, which is Assembly Bill 258, revising provisions relating to brokerage agreements. And we welcome Assemblymember Moore and Ms. Reese.
Good morning, Chair Pazina and members of the committee. My name is Assemblymember Cynthia Moore, CINTHIA-MOORE, and I represent Assembly District 11 in East Las Vegas. Today I'm here to present AB 258, and I'm bringing AB 258 forward to make sure Nevada is following the National Association of Realtors settlement agreement, which stemmed from a lawsuit regarding brokerage agreements. As you may know, the lawsuit emerged out of the need to address long-standing concerns over certain brokerage practices that were affecting transparency, pricing, and competition in the marketplace. By aligning Nevada's laws with the settlement agreement, we are not only protecting our consumers, but also enhancing the integrity of our real estate market in Nevada. This legislation will help create a more equitable and transparent framework for all parties involved in real estate transactions, ensuring that our state meets national standards and remains a leader in protecting the rights and interests of Nevadans. With me today, I have Brandon Roberts, the Nevada Realtors President, Jenny Reese with Carrara, Nevada. Chair, if you don't mind, I would like to turn it over to Brandon Roberts to provide additional testimony on this bill in Las Vegas. Thank you.
Wonderful. Thank you so much.
Good morning, Chair Pazina and members of the committee. My name is Brandon Roberts, BRANDONROBERTS, and I currently serve as the president of Nevada Realtors. I have over 28 years of experience in real estate, including more than 22 years as a broker. I would like to express my appreciation to Assemblymember Moore for introducing AB 258. As you may be aware, the National Associations of Realtors settled a lawsuit last year that involved brokerage agreements and commissions. One recommendation that came out of the resolution is that all brokerage agreements must be in writing before performing any service, including showing homes. This agreement must clearly outline the services to be provided and the associated costs to the consumer. Nevada Realtors fully supports this change because we believe it benefits the consumer by ensuring they are properly represented. A written agreement provides transparency, helps buyers and sellers understand the role of their broker, the scope of their services, and the associated costs. This added clarity enhances consumer protection and trust in real estate transactions. Currently, Nevada law allows brokerage agreements to be either oral or written. Section 2 of AB 258 eliminates the option for oral agreements, ensuring that all brokerage agreements must be in writing. The subsequent sections of the bill make necessary adjustments to align existing statutes, removing the references to written agreements, since all brokerage agreements will now be required to be written. For example, Section 4 of the bill relates to exclusive brokerage agreements, which previously had to be in writing. With the bill, both exclusive and non-exclusive brokerage agreements will be in writing. It is important to note that the settlement agreement of the class action lawsuit covers realtors, while this proposed amendment would apply to all real estate licensees under Chapter 645, offering additional consumer protection. Additionally, this bill applies only to residential brokerage agreements. Commercial brokerage agreements are specifically covered by another statute within Chapter 645 that are not amended by AB 258. All commercial brokerage agreements are already required to be in writing under the current law. I appreciate your time and consideration of AB 258, and I urge your support for this important measure to strengthen consumer protection in Nevada's real estate industry. Thank you, and I'm happy to answer any questions you may have.
Thank you so much. Do you have any further presenters?
Cynthia Moore for the record. No, I do not.
Okay. Thank you so much. Committee, do we have any questions? I'll ask a quick question. So what percentage would you say, and you may not know, and that's okay, but I'm just curious, what percentage of residential agreements were oral prior to looking at this change?
Jenny Reese for the record with Carrera, Nevada. Do you mind if we defer to Brandon if he knows that?
Absolutely. And if you don't know, that's okay too. I was just curious.
Brandon Roberts for the record. The majority of transactions in the past were done with oral agreements. Most realtors or real estate agents did not get signed buyer agency agreements.
Cynthia Moore for the record, Chair. I just wanted to add, as a realtor, I've been a realtor in Nevada since 2019. And I have always made sure that my broker-buyer agreements were in writing just to help protect myself and our brokerage. But I do know that other realtors in my previous brokerages were not doing them in writing until they got further along in the transaction.
Thank you both so much. And I believe Senator Ellison and then Senator Daley had questions too.
Thank you. I bought a house just a while back. So how long is this process after the lawsuit come into effect? I didn't catch that.
Right. Yeah, Brandon Roberts for the record. The effect went in, I believe, August 27th of last year.
We've had good response with our realtors, really good. I was just, because when I read the contract, there was 2 realtors on there, and one was probably the general or whatever you call first place and second, whatever. But the real estate agent was great. They sat down and they wrote everything out prior to even putting final offers and stuff on there. So that agreement was good. And I like that up front. So thank you.
Cynthia Moore for the record, through you, Chair, to Senator.
You can go direct, and thank you so much.
Thank you, Senator. For the purposes of this bill, Assembly Bill 258, this will go into effect October 1st, 2025. However, the lawsuit happened last year, and a lot of brokerages were already starting to require this from their realtors. However, we just want to ensure that everybody is following the same thing, and it's not just some brokerages requiring this and others not doing that.
Thank you, Madam Chair, and a little confirmation on that. Every time I have a realtor that's a friend of mine that we call and we use, and we've never done a written agreement on that. But and I know the settlement nationally on that. So I guess my question is, now that everyone's going to have to do a written agreement, They're going to have to read them and try to understand them. It's like a lot of other stuff. So in the settlement, are there parameters or rules on minimum things that have to be in the agreement, things that can't be in the agreement? Because if it's just left up to your own devices, human nature is realtors and the people that write it are going to write it in their favor. I'm just saying if there are any rules and safeguards to balance that for consumers.
Jenny Reese, for the record, if we can defer to Brandon on the agreements, there are certain standards already required in law. You've got your minimum services plus what the duties owed to the consumer. But if you don't mind, I'd like to defer to Brandon on that.
Brandon Roberts, for the record. Yes, I mean, it is clear that you need to state what services you're providing and the actual cost to the consumer. The benefit of these upfront is the buyer will now know exactly what their real estate professional is charging them and what that cost is and what the services and the time frame of that agreement are.
And thank you. And if I recall the pieces of the lawsuit was regarding what portion the seller was paying, what portion the buyer was paying on that, and there was a little discrepancies, and at least in some people's view on the settlement. So if there's parameters already in law on what that's got to be, just we don't want to have another lawsuit and settlement is all. Thank you.
Okay, I don't see any further questions. So with that, we thank you so much for the presentation, and we'll have you all step back. And Mr. Roberts, I'm happy you were able to be here today as well. And we are going to take testimony in support of Assembly Bill 258. Anyone who'd like to come in support in our physical locations? Not seeing anyone, we're going to move to the phones broadcast. Is there anyone in support of AB 258?
If you would like to testify in support of AB 258, please press star 9 now to take your place on the queue. Chair, you have no callers wishing to testify at this time.
Thank you so much, broadcast. We will move to testimony in opposition of Assembly Bill 258. If there's anyone in our physical locations, and again, not seeing anyone coming forward, broadcast, we're back to you. Anyone who'd like to testify in opposition on AB 258 on the phones?
If you would like to testify in opposition of AB 258, please press star 9 now. Chair, you have no callers wishing to testify at this time.
And while we're with you, broadcast, do you have anyone who'd like to testify in neutral on AB 258?
If you would like to testify neutral on AB 258, please press star 9 now. Chair, you have no callers wishing to testify neutral at this time.
And if there's anyone in our physical locations who'd like to testify neutral on AB 258? And not seeing anyone, do we have any closing statements that you'd like to make? Okay. Well, thank you so much. It was a pleasure having you all here today. And with that, we will close the hearing on Assembly Bill 258. And we are going in order on the agenda today. So we will move to Assembly Bill 498, revising provisions relating to motor clubs, and we'll welcome Assemblyman Carter and his co-presenters.
Good morning, Chair Pazina and members of the Senate Commerce and Labor Committee. I'm Max Carter with Assembly District 12, the east side of Las Vegas, and I'm presenting a bill from the Assembly Commerce and Labor Committee, which I sit on. This is a committee bill, and it's one that is the form that I believe, it's not necessarily mandated, but that a committee bill should be. This is about it's an industry bill that is modernizing and streamlining regulations in regards to an industry. So it's Assembly Bill 498 revises provisions relating to motor clubs. The bill removes the requirement for a motor club to provide information about the usual place of business of the motor club in this state It also authorizes an individual who is not a resident of this state to be licensed as a club agent if the state in which the individual resides does not require a license to act as an agent. And with me this morning is Matthew Morris with Holland and Hart and Deborah Poland representing the industry. And I'll turn it over to Matthew now.
Good morning. Chair, not Matthew. Chair Bazina, Vice Chair Daley, and honorable members of the committee. Good morning. My name is Deborah Poland, DeborahPolan for the record, and I serve as General Counsel for the National Auto and Travel Organization, otherwise known as NATO, the other NATO. I appreciate the opportunity to appear before you today in support of Assembly Bill 498 and offer our thanks to Chair Bazina for bringing the measure forward. NATO is a nonprofit organization of automobile clubs. We provide consumers public safety services such as roadside assistance, towing, and lockout throughout the country. And more importantly, 600,000 of Nevadans last year used our services. Many new vehicles come with complimentary roadside, generally provided by one of the NATO members. Some of our members provide motor club services ancillary to products like cell phones or tires that you buy. And I recently noticed that Costco has a new auto program, and they provide roadside with one of our members as well. Our services provide assurance to drivers of new and older cars alike that they won't be stranded on a highway or even in their driveway with a disabled vehicle with no one to call, no way to get to work. NATO companies provide peace of mind that you can call someone 24 hours a day, 7 days a week, 365 days a year. AB 498 will modernize Nevada's statutes that have not been touched since 1971, while maintaining a robust regulatory structure, which we totally support. Currently, an agent from another state that sells to Nevada residents can only get an agent's license if they're licensed in their home state. But here's a problem. The national trend toward motor club regulation is less rather than more. In the beginning, when motor club statutes were first adopted, like in the 70s, only about 30 states adopted motor club statutes. We know it's indemnification for risk, but everybody didn't think it rose to the level of regulation. And in the last several years during my career, several states have deregulated. Louisiana, Virginia, Kansas just recently, and even that last month, North Carolina stopped licensing agents. So it's hard if the majority of states don't license your agents to have reciprocity. This will allow the commissioner to have some flexibility on changing that. By giving your insurance commissioner the flexibility to license a sales agent who doesn't reside in a regulated state, more companies can provide services to Nevadans, and more revenue will be generated in your state for providers like towers, locksmiths, and others. On behalf of NATO, thank you for your time. I'll be here for questions, but if with your indulgence, Chair Pacino, I'm going to now turn this over to Matt Morris to close very quickly by walking you through the provisions of the bill. Thank you.
Good morning, Chair, Vice Chair, members of the committee. My name is Matt Morris, M-O-R-R-I-S for the record. I'm an attorney with Holland and Hart. I'm here on behalf of the National Auto and Travel Organization. Thank you for hearing AB 498 and for the opportunity to very quickly outline the provisions of this bill. As mentioned, motor clubs provide vital roadside, towing, and other emergency services to their members. The intent behind AB 498 is to modernize a few provisions of Nevada's Motor Club Statute, NRS Chapter 696A, which was first enacted in 1971. So walking through the bill, Section 1 amends 696A 190, which deals with the information that a motor club must provide on a contract or a membership card to their members or their subscribers. Under existing law, the membership card or the contract must include, quote, the exact location of the motor club's home office and the usual place of business in this state. An increasing number of entities do not have this information or a physical brick and mortar location in addition to a home office. So to meet this criteria, many entities can only list a registered agent address, which is not the intent behind this requirement to begin with. So AB 498 proposes to remove this requirement. And again, this statute was first enacted in 1971, and it has not been amended in the last 50 years. So this slight revision will help to modernize the statute and better reflect the nature of how business is conducted today. Section 2 amends NRS 696A 290. Now, as previously explained, this statute allows both Nevada residents and non-Nevada residents to apply for a license to sell a motor club membership. Under existing law, a non-Nevada resident may apply for a license in Nevada if their home state also allows non-residents to apply. However, a number of jurisdictions have either repealed their respective licensure statutes at the legislative level or at the administrative level. So under the plain language of 696A 280, non-residents in those jurisdictions would not be eligible to apply. Section 2 would clarify this provision to allow a non-resident in a home state that does not license motor club agents to apply for licensure in Nevada, subject to all of Nevada's existing application and eligibility criteria. And finally, Section 2 also amends 696A 280 subsection 3 to amend the term person to individual, and that's to conform to similar references throughout the statute and distinguish between corporate entities and individual licensees. If adopted, the bill would take effect on October 1 of this year. So thank you once again for hearing this bill, for the opportunity to walk through it. And if I can also just add a personal thank you to Assemblyman Carter for working with us and for being here today and presenting this bill in both the Assembly and the Senate. Thank you, Chair.
Thank you very much. Max Carter, for the record. Chair Pazina and members of the committee, I just want to say that when we heard this in Assembly, Commerce and Labor, it was an afternoon committee. So I see now, not sitting behind us, some of the people that were in support last time. And I just wanted to, it's on the record, but the biggest towing service company down in Southern Nevada, Snap Towing, was in favor of it. More importantly, the registered agents, which maybe they have somebody here, but the registered agents were in favor of it, because that's really one of the big things this does, is it makes it to where these companies don't have to hang their license someplace like we all used to be when we were much younger. You'd see all the time in post office boxes and stuff like that, someplace for somebody to hang their license. That's kind of fading out, especially in this industry. And just FYI, I'm sure you guys have already figured it out, AAA and the likes are the big ones, but this industry has evolved to where now it's car dealerships, insurance agents, as was said, Costco, and so it's a very diverse industry providing these services. And with that, we're open for questions, and thank you very much.
Thank you so much, Assembly Member, and it was wonderful to have you here as well, Ms. Poland and Mr. Morris. Do we have, okay, Senator Ellison.
I hate to tell you this, I bought a brand new truck, and I got here after a couple, 2-3 weeks, and guess what? My truck wouldn't let me in. They called these outfits, and
Senator Ellison, did you hit a deer again?
yeah, they come and fixed it. I mean, it was amazing. It was late at night, colder than heck out there, and they showed up and opened up my truck, and that's what it was. It locked the doors, and the doors wouldn't unlock for nothing. So we thought we were going to have it towed, but they didn't. They come and got in, and we took it to the dealership, and all it was a programming in the truck. But thank you very much, and it worked out great. It worked out really good. So thank you.
I believe Senator Lang also had a question.
Good morning. In the bill, in section 2, number 3, it says that this person is supposed to be a trustworthy individual. I really don't see the necessity of even having that sentence in the bill, because what I see as a trustworthy person may not be what somebody else sees. And so I don't think it's necessary in the bill. So I just want to know why it's in there and if we should have it.
Thank you, Chair, through you to Senator Lang. Matt Morris for the record. Thank you for the question. So subsection 3 is existing language. We've noted this a few times, this is language that's a little bit antiquated. This was passed in 1971, and it's a part of the criteria for what the Division of Insurance used to look at when somebody would apply for a license to sell a membership. And so there are other provisions in existing statute in 696A that deal with consumer protection, deceptive trade practices. As those statutes have been enacted over the years since this initial language was adopted, they've been incorporated by reference. And we're not amending any of that, and so it doesn't appear in the language of the legislation. But what we are doing in subsection 3 is we're trying to make it clear that the term person actually is supposed to refer to individual, a natural human being. And to your point, to the extent that there's confusion sometimes around whether a person refers to a corporation or some sort of business entity, that language about being a trustworthy entity doesn't really fit. And so that's actually the intent behind changing person to individual.
A follow-up, please. So, I think that instead of having a sentence like this, it would be better to have a definition and maybe legal. Like moral turpitude. Yeah.
Thank you so much. We were just discussing, and I should have had my microphone on, that's my fault, that we do put moral turpitude into a number of bills, so maybe that's something we can look at here. And we can continue that conversation if that's something that you would be open to. And we'll talk to legal. Legal, do you have anything to add to that, Mr. Coulomé?
Thank you, Chair. Jeff Coulomé from the Legal Division. Nothing to add off the top of my head. To echo the comments of Mr. Morris, these licenses can be granted to entities, and then an individual person can be granted the powers to under the license, if that makes sense. So I think what Mr. Morris explained makes sense, and if there's a desire to pursue an amendment, obviously we'll be happy to be involved in the conversation if necessary. Thank you.
Any other questions from the committee? I was curious, you mentioned deregulation in a number of other states. So can you explain a little bit more about and I think you did a bit in the presentation, but who's been doing that and why they've been deregulating?
It's Deborah Poland for the record. It's interesting because I've been doing this for probably 25 years, and I was working on a bill in Missouri similar to this to just clarify things, and during my time there, Kansas unilaterally decided to just stop regulating motor clubs. We have not sought deregulation. We like having some oversight because it keeps the bad actors out. But Kansas did it just recently. The same thing happened with Virginia about 10 years ago, and Louisiana about 5 years before that. The agent piece was also unilateral in North Carolina. So those were just examples of states that have done this on their own without any outside parties pressuring or asking for such deregulation. I think it was probably staffing, streamlining. That's all I can offer.
Thank you so much. Not seeing any further questions. I thank you so much for the presentation. And Assemblymember Carter, it's good to see you in here. I haven't seen much of you this session. And again, Mr. Morris and Ms. Poland, thank you so much. We'll have you step back and we will take any testimony in support of Assembly Bill 498, recognizing that this is a Friday morning and you might not get as many people as came in the Assembly.
Morning, Madam Chair, members of the committee, and staff. Looking at staff here. My name is Rick McCann, M-C-C-A-N-N, for the record, and I am representing Snap Towing. I know most of you know me as the guy who represents cops, but I apparently can't keep a job, so I'm now with Snap Towing this morning. We are here to fully support, very quickly, AB 498. And just for the record, I am very happy that we were able to get Senator Ellison back into his truck, because I can only imagine the problems that we would have had if we hadn't. So thank you very much.
Thank you so much, Mr. McCann. We're also very happy that Senator Ellison was able to get back into his truck. Not seeing anyone else in our physical locations broadcast. Let's move to the phones. Do we have anyone who'd like to testify in support of Assembly Bill 498?
If you would like to testify in support of Assembly Bill 498, please press star 9 now. Caller with the last 3 digits of 874, please press star 6 to unmute. Please continue.
Good morning. I'm Jeff Cochran, JEFF-COCHRAN. I'm the president of the National Auto and Travel Organization. I'm calling in support of the AD 498. I'd like to thank you for your consideration.
Caller with the last 3 digits of 445, we can see you are unmuted. Is it possible you are muted on your end?
Oh, yes, I was. Thank you. Can you guys hear me now?
Yes, please proceed.
Thank you. My name is Peter Necklace, Nechelles. I'm the general counsel for the Cross Country Motor Club, and I'm calling to support AB 498 on behalf of our motor club, as well as the motor club industry. We appreciate very much the ability to assist the residents of your state, and we look forward to continuing the role we have with your residents. Thank you for your consideration.
Chair, you have no other callers in support at this time.
Thank you so much. Since we've been having so much fun with you broadcast, we're going to stay with you. Is there anyone in opposition of Assembly Bill 498 on the phone lines?
Chair, your public line is open and working, but you have no other callers on the line.
Thank you so much. Is there anyone who'd like to testify in one of our physical locations in opposition of AB 498? Not seeing anyone. Is there anyone who'd like to testify in neutral on Assembly Bill 498? Oh, we missed you. It's been a little while. Come on up.
Thank you, Madam Chair, members of the committee. Adam Plain, Plain, with the Nevada Division of Insurance. The division's neutral on Assembly Bill 498. Did submit written testimony, very lengthy paragraph. Not really. Talking about the very few provisions of this bill, the division's fine with the change about disclosing the location. For most intents and purposes, that's really only used if a consumer needs to file a lawsuit. And under Nevada Revised Statute 696A.180, they can always serve process against the Commissioner of Insurance, who will then forward it on to the motor club in question. So not disclosing or not having a physical location is no longer an issue. The reciprocity issue is one that we agree with. Under current reciprocity statutes, we are not allowed to issue a reciprocal license to someone who can't get a license in their home state. So clearing that up is perfectly fine. And then on the issue of the personhood item, I just wanted to clarify, 696A.280 is geared towards individuals, right? The commissioner shall license as a club agent only an individual. So the change in sub 3 from person to individual does make sense to us as a division. In sub 3, talking about trustworthiness, I did just get on with staff. The division does not do full background checks on motor club licensees, but we do run clear reports, which are background information, but not to the full extent of a DPS check. And we do maintain that there's trustworthiness, right? You're inviting these folks into a situation where maybe you're alone on the side of a road at your home, and so we do want to make sure that someone doesn't have a potential history of criminal activity or whatnot. And I'd be happy to answer any questions.
Okay, I agree with you. And I am alone on the side of a road, and I have been before waiting for a tow club to come get me. I was very happy that it was trustworthy individuals or with moral turpitude or however we want to define it. So, agreed. Okay. No questions. So, thank you so much. I don't see anyone else who's here to testify in neutral. And let's head back to the phone lines. Do we have anyone who's here to testify in neutral? I might have already asked you, broadcast, and I apologize if I did, but let's do one more check.
If you would like to testify neutral on AB 498, please press star 9 now. Chair, you have no callers wishing to testify neutral at this time.
All right. With that, Assembly Member, if you'd like to come up and make any closing statements, or if any of your other presenters would like to join you.
Thank you, Chair. Max Carter for the record. I just want to reiterate that this is kind of the core purpose of our Commerce and Labor Committees, streamlining and modernizing regulation while at the same time making sure that Nevadans are protected. And I think you can see by the testimony that this is kind of how industry bills should go, where the neutral testimony, the regulator, is much longer than the support or opposition. We're just working with the industry to smooth things out. Thank you so much.
Thank you so much. And with that, we will close the hearing on Assembly Bill 498, and we will open the hearing on Assembly Bill 510, making various changes to the regulation of accountancy. And we will welcome Mr. Hillerby and any co-presenters.
Thank you, Chair. Good morning. Michael Hillerby on behalf of the Nevada State Board of Accountancy. And with me is Vicki Winfield, the Executive Director of the Board. We'll do a quick overview of the bill and then be happy to answer any questions. I thought I'd start with just a little bit of background. The accountancy profession and the regulation of it has had a fair amount of uniformity for a long time. There is one national exam and there are similar education and experience requirements across the United States. In fact, that exam is recognized in 55 states and territories, and now 6 foreign countries have a version of the exam that's recognized in the United States. The Uniform Accountancy Act dates back to 1916, and the first model bill was 1984, and this state has been good about adopting those and working toward those national standards. This body over the years has looked at and directed us and all licensing boards to look at how to standardize and streamline licensure, make it easier for people to move in and out of the state. We responded with what is in the accountancy world known as mobility, meaning license recognition for individuals in 2009 and for firms in 2023. And the majority of states have adopted versions of this as well. What that means is accountants that come here to do business from other states do not need to come get a license, do not need to pay a fee in Nevada, but part of this national standard is then they essentially agree and acknowledge that if there is a complaint or an investigation, we can go to their home state where the license is. So it makes it very easy for people to come in here and take care of their customers. The national organization, the National Association of State Boards of Accountancy, and working with the profession, the American Institute of Certified Public Accountants, has been working to expand the educational and experience pathways to become an accountant, and this bill reflects that and sort of moves our regulations in that direction. I'll quickly go through the bill and then we'll be happy to answer any questions. Sections 1 and 4 deal with the examination and specifically the time allowed to take that. Currently in regulation, and that's NAC 628040, allows applicants up to 18 months to take all of the sections of the exam and successfully pass that. What's happening nationally starting in 2023 is there is a move to give applicants up to 30 months to do that. It is a complicated exam and it's hard. You need to also gain experience requirements before you finally get your license that are signed off on by a CPA. And again, this reflects what's happening nationally, and that's Section 1 and 4. Section 2, we're seeking to take out some of the specificity of the education and experience requirements and move more of that into regulation, which obviously you all approve through the Legislative Commission. The details you see us hoping to take out in Section 2, you'll find those and more in Nevada Administrative Code 628055. A lot of that detail on the 150 hours of 150 semester credit hours of education and the other experience requirements you'll find there. Section 3 of the bill that removes a fee. It is one of 2 places in Section 3 and Section 6. Sorry, we're looking to remove fees. Section 3, currently there is a fee that is now outdated in regulations to sign off and inspect the experience requirements. Since those are now signed off on by a CPA, we no longer need to do that. So by changing the statute, we'll be able to remove the fee that's currently $1,000 that's set in regulation. And Section 6 references, Section 6 references a fee for out-of-state firm registration. Since we no longer do that, that language would change the fee from mandatory to allow the board to do that if necessary by regulation. And again, the regulations will be updated to reflect that as well. Section 5 of the bill just makes a conforming change to acknowledge that the regulations are set under the authority in NRS 628-200. That is the basic overview of the bill, and again, the changes that we would be seeking to make to match this in regulation would, of course, go through the public hearing process and then ultimately to the Legislative Commission for approval. We'll be happy to answer any questions.
All right, committee, do we have any questions this morning? Senator Daly.
Thank you, Madam Chair. And I'm looking over this, and I know you have an ability to put a lot of stuff into regulation as the statute reads now. So in Section 3, it said, they word it a little bit differently. So what is the amount now, and planning any changes? Similar with the time limits that is provided for in Section 4. What's the time limit now, and are you guys anticipating any changes?
Thank you, Michael Hillerby. Senator Daly, the current fee in NAC 628-016 that is referenced in Section 3 is $1,000, and that would be going away because the experience requirement are now signed off by CPA. And in Section 4, the time allowed in regulation now is 18 months, and we'd be moving to 30 months, seeking to do that by updating the regulations.
10-4, and understood, thank you, but it wasn't clear that the fee was going away the way it's written here, unless you go look at the regulation on that further. So that part of the regulation would be amended out because you're no longer doing that particular service. And then I suppose I can ask it if I'm there when we get to the Legislative Commission why we go to 30 months, but nevertheless, that's it. Thank you.
Okay. Any other questions? I have one brief one. So you mentioned now it's 30 months instead of 18 months to pass all sections of the exam. Was that just to get in line with what people are doing in other states? What was the reasoning behind that?
Thank you, Chair Pizzina. Michael Hillerby. Exactly. As the profession and the National Association of State Boards of Accountancy have looked at finding ways to help people get into that the profession, it's a tough exam. Our nephew, my wife's nephew, just took that recently while working at the same time. It's a tough exam. It demands a lot, so that provides more time to do that and get while you're also getting your experience. So that's what we're seeing as the national standard that's coming out, and this would again allow us to update the regulations accordingly.
Thank you so much. I think we have one more question from Senator Ellison.
Thank you. And, a lot of times if they flunk the tests and they make them wait so long and do extra studies or whatever to retake the exam, is that in the process with the accounting also?
Vicki Winfelt for the record. It's actually a rolling 18 months, and it's a 4-part exam. And so the 18 months or 30 months now starts the first time you pass the exam, and then you have to get the other 3 parts of the exam finished within that 30 months. And so it's extending the time. It used to be 18 months, or the national trend was 18 months, only a year and a half to get all 4 parts taken. And the pass rate of the exam is not that great, and so we find that more people have to retake the exam. So your next 18 months would roll to the next passed part. So by expanding that to 30 months, it gives them quite a bit more time to get those 4 parts completed. Does that answer the question?
Yes, it does. Thank you.
Thank you. And out of curiosity on the test, is there a certain time frame where you can take the test? So you can only take it once every 4 months, or could I go back the day after I failed said exam? And I also am not an accountant, I will say, I'm just curious. But if I were to take part of the test and then fail it, could I go back the next day? Or do I need to wait a certain period of time?
There's a certain period of time, but it is a continuous test now. It used to be where it was only offered 4 times a year, but it's continuous, but within a window. So you have to wait for those exam scores to come back. Once the exam score comes back, then you can apply and sit for that part again.
Understood. Thank you. I think that helps us understand the 30 months a little better, knowing that you have to wait so long in between test taking opportunities. I don't see any other questions, so we thank you so much for the presentation, and we will have you step back so that we can take testimony in support of Assembly Bill 510, and we'll start doing that in our physical locations, and then after that we'll move to the phones.
Good morning. For the record, my name is Anna Durst, ANNADURST. I'm a Nevada Certified Public Accountant, and I'm the Chief Executive Officer of the Nevada Society of CPAs. The Society represents the CPA profession for the entire state of Nevada. I appreciate the opportunity to address Chair Pizzina and the members of the Senate Commerce and Labor Committee to voice support for AB 510. We've submitted written support and would like to focus on a few items related to AB 510. The Nevada Society of CPAs has worked with the Board of Accountancy as they drafted bill language to make conforming changes to certain areas of NRS 628, adopt updated regulation, and move CPA licensure requirements out of statute and into regulation. We feel these changes further align Nevada's licensure requirements with the Uniform Accountancy Act, which most states adopt in various forms and fashions. Furthermore, we believe the proposed changes to NRS 628 will remove barriers to licensure, clarify licensing requirements, allow CPAs to better serve Nevada clients, and attract businesses and CPAs to the state, which we desperately need. The CPA profession nationally is undergoing rapid transformation, and licensure nimbleness is necessary to keep up with the change. This proactive approach from the Nevada Board of Accountancy continues to modernize the Nevada CPA license while maintaining public protection. We encourage passage of AB 510 and appreciate the opportunity to provide support. Thank you.
Thank you so much for being here today. And with that, we will move to the phones for any testimony in support of Assembly Bill 510 broadcast.
Chair, your public line is open and working, but you have no callers at this time.
Thank you so much. We will close out testimony in support of Assembly Bill 510 and move to any testimony in opposition. Seeing no one coming forward in our physical locations broadcast, that brings us back to you. Is there anyone on the phone lines in opposition of AB 510?
Chair, you have no callers at this time.
So I will ask the question, which I'm guessing you will tell me there are no callers at this time, but do we have anyone in neutral on AB 510?
Your public line is open and working, and you have no callers this time.
Thank you so much. To our physical location, is there anyone who would like to testify in neutral on Assembly Bill 510? Seeing no one, would you like to make any closing statements? All right. Well, we thank you so much for the presentation today, and that will close our hearing on Assembly Bill 510, and that will move us to our final item on the agenda, which is Assembly Bill 511, revising provisions relating to insurance, and I believe our presenter is coming forward in Las Vegas right now.
Thank you, Chair Pizzina. Dr. Yeager for the record, Jaeger. And my opening joke for the morning is that Speaker Yeager and I have debated on how we spell our names correctly, and we're still, the jury is out on the proper spelling. For the esteemed committees of Senate Commerce and Labor, thank you for allowing me to come before you today. So my name is Dr. Yeager. I am a fourth generation Nevadan and Las Vegan. My family came here in the late 40s to build the neon sign industry with a company called Young Electric Sign Company, YESCO. I'm proud to say I've been married in Las Vegas for 24 years and raised two fine young men that went to Faith Lutheran High School and are now in college. I am the CEO of Advanced Spine and Posture. We are a medical corporation based in Nevada and operating in 2 states. We are a medical corporation that employs medical doctors, physician assistants, nurse practitioners, physical therapy doctors, and chiropractic physicians. I also serve on various boards, both at a state and a national level. I'm on the National Board of Chiropractic Examiners as the vice president. We are the postgraduate testing agency for chiropractic physicians, similar to any other healthcare or professional licensing entity that does independent testing. I'm also the treasurer and secretary of the Chiropractic Physicians Board of Nevada, as well as past president and chair. I sit on a research board called Chiropractic Biophysics Nonprofit, where we've currently published over 366 papers in the medical, scientific, and peer-reviewed literature on spine-related health. And then most recently, I've joined as a board member for the International Chiropractors Association, which is an agency that advocates for chiropractic's promotion in the country and around the world. I'm not here today on behalf of any of those entities, but instead as the chair of the Insurance and Equity Committee for the newly united Nevada Chiropractic Council, as well as the Nevada Chiropractic Association. So the insurance industry in Nevada has not been consistent with the Nevada Division of Insurance. I presented to you all a very robust PowerPoint presentation, and I'm sure you'll be happy to hear that I'm not going to go through every one of those slides, but instead just cover the highlights. So when we look at equality in healthcare providers, first it's important to look at what the Center for Medical CMS defines physician as. And there's 6 healthcare provider licenses that are considered to be physicians. This includes medical doctors, doctors of osteopath, podiatric physicians, dental physicians, doctors of optometry, and chiropractic physicians. Also in Nevada state law, chiropractors are one of the healthcare provider types that are considered physicians. Importantly, with the Affordable Care Act, Section 2706A details that there has been a history of insurance inequality that has gone on throughout the nation. And in 2013, there was legislation that was brought forward on 2706A that specifically looked at making sure that discrimination did not occur. With that, we've located within the Division of Insurance sections of NRS 689A and 689B, which govern insurance, specifically group healthcare plans as well as individual. And looking throughout the sections related to chiropractic as well as other healthcare providers in Nevada, what the language read was that healthcare providers shall not be discriminated in how they are reimbursed, similar to other health care provider types. But of interest, the language from 1983 stated that the insured is entitled to reimbursement for the treatments. So I want to really parse this language. The insurance company would reimburse the insured. What we're seeking for with this simple language cleanup, both for chiropractors as well as other healthcare provider types, is the current 2025 landscape with health insurance, which is a Nevadan seeks care, they submit their health insurance, and the insurance company pays the provider directly. This simple language cleanup, we feel, accomplishes this goal, and I really appreciate your time and your consideration today.
All right. Do we have any questions? I believe Senator Daley has a question.
Thank you, Madam Chair. And question, comment, so if I understand this correctly, and maybe our insurance guy can come up and tell us later. So the insured is the one that has the insurance, and the way this language is written is that he's entitled to be reimbursed for anything that he may have been paid. So how universal is it? And I guess we're making an assumption that it's universal, because the normal way is now when you go to the doctor's office, you sign an assignment of benefits. They say, hey, we'll turn this into the insurance, and you've assigned your benefit to the doctor that's providing the service. But I don't know that that's universal for sure, and it's typical. But I know the insurance company won't pay the person that's insured unless they show they paid the bill. Then they'll actually reimbursement, because that's a reimbursement after they've paid the doctor. So how universal is the assignment of benefits? Is the assignment of benefits required? Or is it just a doctor says, I'm not going to give you a service or recognize your insurance unless you assign the benefit? How universal is that? Because we're making a few assumptions here that everybody's using the assignment of benefits, that every patient is going to sign off on that, and then this takes away potentially or creates confusion on the part of the insurance company that says, well, it doesn't say I have to reimburse you, the insured person, whether you paid or not. You see what I'm saying?
Senator Daly, thank you very much. Dr. Yeager for the record, Jaeger. That's a really good question. When we presented this in front of the Assembly Committee on Commerce and Labor, there was neutral comment from the Division of Insurance, and I believe that there could be an opportunity for the answer to that question to be better clarified from them. Speaking as a Nevada licensed healthcare provider, I became licensed in Nevada in 2002. I went to school in Southern California, became licensed there in 1999. In my years in practice, it has been typical that there's an assignment of benefits, and typically the insured, the patient, will present their health insurance benefits to the provider. The provider verifies those benefits and then provides a service and is subsequently reimbursed for said service.
Understood, and that's how it's always worked when I went in. Hey, do you have your insurance card, et cetera, et cetera. And I guess the only situation where that's not the case is emergency medical stuff, where if you don't have insurance, they have to treat you anyway. Although the assignment of benefits 99% of the time happens in that situation as well, if they have insurance at all. I was just wondering how universal it is, and we can wait for more information from our insurance, state insurance regulator when it comes up. That was it, Madam Chair. Thank you.
Senator Daly, if I may add, Dr. Yeager for the record. The other thing I would note is that as we look at the language that we're proposing amending, it is language that relates to insurance as opposed to language relative to a patient that, for example, doesn't have insurance or would be seeking out-of-network benefits. Thank you.
All right. Do we have any other questions from the committee? No one is making eye contact with me, so I'm going to take that as a no. Thank you so much, Dr. Yeager, and you may step back from the table, and we'll take testimony in support of Assembly Bill 511. We'll start in our physical locations and then move to the phone lines. And seeing no one coming forward, broadcast. Is there anyone on the phone lines who'd like to testify in support of AB 511?
If you would like to testify in support of AB 511, please press star 9 now. Chair, your public line is open and working, but you have no callers at this time.
Thank you so much. And with that, we will move to anyone who'd like to testify in opposition of Assembly Bill 511. Not seeing anyone coming forward in our physical locations, we're back to you, broadcast. Anyone who'd like to testify in opposition of AB 511?
Chair, your public line is open and working. You have no callers at this time.
Well, then I'm going to take my chances, broadcast, and stick with you. Is there anyone who'd like to testify in neutral on AB 511?
You have no callers at this time.
Thank you so much. And we are going to move to testimony in neutral in our physical locations, and we are going to welcome back Adam Plain, who we've missed after a bit of absence.
Thank you, Madam Chair, members of the committee. Adam Plain, P-L-A-I-N, with the Nevada Division of Insurance. As a quick aside, I was joking with Senator Ellison before the hearing today that despite the Assembly having considerably more bills overall, I believe the Senate had far more bills dealing with insurance. So in these last 35 days of the session, as the Assembly bills come over here, you'll probably be seeing me less, unfortunately, because I will be upstairs more often.
You will be missed.
Thank you. To the topic at hand, Assembly Bill 511, Division of Insurance is neutral on the bill. We understand the intent and need for the cleanup in this particular language. Don't really see an issue with it. I think to Senator Daly's question and to some of the thoughts, if we look at, for example, Section 2 of the bill dealing with NRS 689A.048, that language is original from like 1979, if I remember correctly. Back in the 70s, 80s, pure indemnity plans were common. Under a pure indemnity plan, as a policyholder, I would go to any physician I wanted, receive the care, submit the bill to my insurance. They would indemnify me or pay me, reimburse me for those costs. Now, pure indemnity plans, virtually non-existent. You do not encounter them. The closest thing we have is an out-of-network benefit, which might indemnify you for receiving care from a physician who's not in your network. But most network plans, you go see your physician, they're the ones that submit the bill on your behalf. They receive the reimbursement from the insurer. So this language does fit with that model much better. As I was sitting in the audience, not to throw a monkey wrench in anything, but it may be worth considering, and I can check with our staff just to be sure, instead of necessarily deleting the language that talks about the insured is entitled to reimbursement, maybe keep that, but still add the additional language about the provider also being able to be reimbursed, just to make sure that we're not accidentally removing those out-of-network indemnity reimbursement opportunities. Not to cast aspersions, I think the language is probably wanting to be corrected because it can be weaponized at times. If a insurer, for example, doesn't like a particular provider for whatever reason, they may say, well, according to the statute, I'm not paying you. I'm paying the consumer. Because that's what the statute literally says. And so cleaning that up, definitely okay with the Division of Insurance. Just want to make sure we don't cause an unintended consequence on the other side. Happy to answer any questions.
Thank you. I believe Senator Daly does have a question for you.
Thank you, Madam Chair. And that goes right along with what I'm saying. Every time I've been to the doctor, anybody I know has been, they're filling out the paperwork and you're making an assignment of benefits because they want to know your insurance. You prove they have the insurance. They'll see you. A lot of times if you don't have insurance, they'll say, how are you paying? Or they won't see you. Everybody has the big disclaimer up there. They say, hey, you're responsible for paying this. And then they work with you. They send it into the insurance reimburse them. They tell you this is your copay, you pay that amount done on, and then you get your explanation of benefits, and if you still owe more, you've got to take care of it going forward. But along the lines of what you're saying, in different scenarios, if a person is out of network, whichever it is, and I'm just reading, because there's a reference in Section 7 and Section 18, when I was reading it, existing language, there's a reference to an assignment of benefits. And then they reference 687B 409. Not exactly on point, but it seems to me that this language that you're going to pay the provider is the normal, as long as there's been an assignment of benefits. And I think we just got to make that part of it clear is, the insurer is the one, because I know the insurance companies, our providers, people that we have, they're not going to reimburse the patient unless he proves he paid. They have to submit a bill that they paid, then they'll reimburse them. Otherwise, it's all going to the doctor. So I just think there needs to be some language about an assignment of benefit before this is automatically done.
Thank you, Senator Daly. Adam Plain for the record. Yeah, I agree. I think your comments about experiences that everyday consumers have in the current environment is correct. They sign the assignment of benefits along with all the other paperwork saying that if the explanation of benefits and the actual adjudication of the claim comes out differently than their estimate, you may owe more than what your copayment or coinsurance was, for example. All of that is part of the upfront portion. Talking specifically about the statutes, Section 7, some of the other statutes, editorializing just a slight bit, some of these chapters in Nevada's revised statutes dealing with health are kind of a hodgepodge, right? Mandates and statutes have been, some of these are as old as 1979, some of them are 2023. The drafting style has changed over the decades. The targets of what we've gone for have changed over the decades. So I think that's why some statutes talk about assignments of benefits. Some of the other ones, especially the very old ones, don't talk about assignment of benefits. I don't know that from the division's standpoint we would have any issue with adding that language. Whether we want to undertake that effort at this time is up to the legislative body.
And thank you again, Madam Chair. It just seems to me if we're here, we should eliminate any question or confusion on that, because clearly the provider would be entitled, the way this language is done, the insurance companies are not going to double pay unless there's a mistake, but nobody does it unless there's an assignment of benefits. And I just think that language needs to be added in there to be made clear. You can get it, and the provider should be paid, no question, conditioned on that assignment of benefits. And I don't think it would be that hard for our people to draft, but I think we should make that clear, my personal self. So hopefully we can get that done.
Thank you, Senator. Adam Plain for the record. I would be happy to commit to going back to Division of Insurance staff, making sure there are no unintended consequences, and then following up with committee staff, hopefully later this afternoon, with an opinion so that you can deliberate on it.
Thank you so much, Mr. Plain, and I look forward to having you consult with Mr. Coulomé and figuring out after your discussion with Department of Insurance, and then we can get back to Dr. Yeager on this as well. Mr. Coulomé, do you have anything you'd like to share?
Thank you, Chair. Jeff Coulomé from the Legal Division for the record. Happy to follow up with the conversation. Quick point specific to the section that Senator Daley mentioned that specifically calls out the assignment of benefits. Without diving into it too deeply here off the top of my head, I think that particular section is specific to drug and alcohol counseling in an out-of-network situation where there are additional benefits that are contemplated that aren't necessarily for the insured per se. There could be counseling that involves family members, I think, is part of that. And so I think there's a reason why that particular statute is different, because the scope of what's being discussed there is a little bit different than a run-of-the-mill doctor's appointment situation. But I don't have more detail than that at this time, but I believe that's why that one section 7, I think, in the bill you mentioned is different than many of those other sections. So just if that's helpful at all for the conversation.
Thank you so much, Mr. Plain, and we appreciate having you here. And I'm sure after this, you're not going to miss us as much, huh? Any other questions? I don't see any from Mr. Plain, so thank you so much for testifying in neutral today on AB 511. And with that, we had already checked the phone line, so we are going to hand it back to Dr. Yeager to close if he'd like to make any closing comments.
Thank you, Chair Pizzina, and to the committee. Also, Senator Daley, I think those comments were excellent. And after listening to the totality of the discussion, the Nevada Chiropractic Association also would be in support of having language that covers both of those elements, both the insured or the Nevada resident or the patient, as well as the healthcare provider. I would ask that we be allowed to collaborate and be included in the potential language with the Division of Insurance. We've worked together pretty closely on this topic since 2017, and this now our third legislative session. So I'm excited to make sure we get it right, and and we really think out everything that protects our Nevada residents. Thank you for having me today.
Thank you so much, Dr. Yeager. And with that, we will close the hearing on Assembly Bill 511, and we'll move to the last item on our agenda today, which is public comment. Members of the public may provide public comment in person, by phone, or submit written public comment to the committee's email. Instructions for providing public comment may be found on the agenda, including the call-in information. We look forward to hearing your comments. We ask that you keep them brief and avoid repetition of comments that may be made by previous speakers. Please clearly state and spell your name for the record, and we'll begin with public comment from those in our physical locations and then move to anyone who'd like to call in. So if anyone would like to come up to the tables and make public comment, we welcome you. Sir, would you like to make public comment at the table? Yep, go ahead, have a seat for us and hit the microphone so that we can all make sure we hear you and keep it on the record. And thank you.
Good morning. My name is Patrick Blackshire, Patrick B. I'm from Sacramento, California, born and raised as an Aboriginal Native, car guy, wheelman, chief of the Wheelman Tribe, VP to A1, Heavenly Angels Worldwide. Foundation of Future Success Charity, the ladies' wing is Beta Alpha, Beta Sigma Beautiful. It looks like baby Greek letters. That can be seen there. We need government funding for housing, resources to help people be successful. Was the email received by council? I just emailed CL, send.
So that'll go into our committee address, and after the committee meeting, our committee staff will have an opportunity to check that out. And thank you.
Anyone receive that email? Yeah, no, not you. I ain't checking emails. You're busy with other things. Okay, so I'm gonna keep it very, very brief and keep from going into a too personal of an issue. First, just to relate, I'm the only man of color, of dark color here, but I'm 12% Welsh. VP of the Heavenly Angels Worldwide, which is predominantly Italian, Native, and white people. You know, just to relate, because I may seem just like I'm sticking out like a sore thumb, like a big Black Panther walking through the room, for example. Goals. We talked about goals of insurance, education in specifics, transportation. Those are great goals for the community. They're very important for the many people that you serve, the constituents, and I respect that highly. Just to show I was paying attention. Needs. Okay, this is very, very small to you guys, but there's a baby on the way. And the mother of the child is having a mental, emotional breakdown at this time. Being 40 years old is already a high-risk pregnancy for this young lady. Her child, her oldest child, around 22, born in 03, he's an 03, his father died. And me as a minister, the agent for a 501c3, the same business license church raised by a Vietnam vet, Bishop Harris, who taught me in ministry. I never became ordained, probably next month, because I'm becoming far more serious about life. You see on the back of my shirt, Romans 12:2. So to make it brief, this young man is in jail. The Bible mentions stealing to eat. Let it be forgiven. You know, that he has, I can't say repented, but he has expressed that he did need to steal, or she shouldn't have been stealing. We can't say that he was, but anyway, we shouldn't be stealing. And so, due to him being in jail, his father being deceased, and me stepping in and helping the family, his mother having a mental breakdown at this point, he has a no bail warrant. I drove from Sacramento to Butte to Nevada City and came here in hopes to bail him out. He has a no bail warrant. I called the court, the clerk hung up on me after explaining for like 5 minutes in distress, irate distress, because the mother could lose her child. She has right now a whole mental, emotional breakdown that is extremely traumatic. And I don't want to go into the drama and too personal, but with communications between the court, the probation, the senators who have the ability to write laws by the stroke of a pen, to quote Kamala Harris, well, I gotta respect, you know. Despite whatever politics are involved. I've seen letters delivered to Trump, not through the USPS. And Trump made a difference in when he was keeping kids, well, not he was keeping kids, but when kids were coming and being separated from their families and being kept in cages like animals. I seen Obama send back a letter because of my work in canvassing, registering voters in my neighborhood. They call me Pope, P from Oak Park with a middle name Edward. Rest in peace to the Pope who just passed.
Yes, we usually keep comments to 2 minutes. We're about 3 or 4 right now, but I want you to finish up. So please go ahead and finish up for us. And thank you for being here.
And just to finish, so I would be talking about my nonprofit getting funding. I emailed you guys about that. Foundation of Future Success needs housing to help people to be structured. Right now, I could be housed in the jail. With that type of funding for people getting their education, that would be more valuable for the community that we're developing transportation and education, CPAs, the things you guys talked about for. So I would like funding for my charity so we can get some land and build affordable student housing and structure a program for people to be in transition with their goals that don't have resources. There's a 2% graduation rate for ex-foster youth, less than 25% for those who don't have parental support. The young man who has been emailed the information to you needs to be collaborated with the leaders here, if it takes a government pardon, it's very minor if a man steals to eat. Not no admission of guilt, but this is something that he can be delivered to the family, bringing ease to the mother so she doesn't lose her baby, so that she doesn't further lose her mind. He's been down for about a month. That's even time served. Whatever it takes to get that man out. And so I would be talking about billions of dollars, millions of dollars, $100, thousands of dollars, just to support the charity. We have an orphanage in Kenya. We're giving out 4 pallets of food with a partner charity out of a community center I founded on Stockton and Fruit, which was one of the most grimy, dirty, hood, ghetto parts of Sacramento, like where Jews, like the ex-Jews, Hebrews, for example, considered ex-slave. Me as a natives. Would live the definition of ghetto, and there I started a community center, 1,900 square foot, no government support, giving out 4 pallets of food with partner charity. So this is the mission.
Thank you so much. We're actually because we're supposed to stop at 2 minutes. I want you to finish up for us. So tell us
who can follow up with me about that.
So we'll look for your
making
email.
Sure that man gets out so his mama can get her mind, because
We'll
she's
look for
losing her
your
mind,
email,
and I don't
and
want her
thank
losing
you.
the baby as well.
Of course, and thank you so much for being here today. We really appreciate it.
Anyone will follow up about this issue.
Well, once
It
we
cannot
see
be
the
swept
email,
under-
we will
under-
follow up.
amongst the whole state here. And I hate to bring something so personal, so dramatic, but I don't want the baby to die. And the man could lose his home and be homeless, and he's trying to be gainfully employed, educated. I apologize about the time. Time is God and planets are his stopwatch. Yahweh, Allah, Jehovah. I ask for y'all mercy so that man can be immediately released. He doesn't have court date set till 5/13 in a no bail warrant. I came up here with the money in my pocket to get him out, and not knowing it's not even posted online that it's a no bail warrant. I came to get him and help him, embrace him. I wasn't allowed to go into the jail as a clergy visit, though I'm an agent for a 501c3, which is the same business license as the church. That makes me a minister, and I will go get licensed. You can get it online today. Who will follow up about
Thank you.
this?
I can promise I'm going to look for that email.
Okay. And then, I mean, you could house me right now in jail, but where's that type of funding for the
And we
the
also do have
charity?
housing bills that we're hearing here next
Yes.
week. So I'm happy you mentioned housing
from
because we're
Sacramento.
going to be
I'll
talking
tune
about
in.
those next week.
I'm glad you guys care. I know somebody cares. Is there anyone here who don't care?
Everyone cares or we wouldn't be here doing this. And we thank you because you care
time.
too, and we thank you.
And today I'll hear back from somebody, right?
I don't know if it will be today because sometimes it takes a while to actually find answers.
Like the clerk hung up with me. I was going to talk to the judge, and if I whatever email get the legal ease from the actual attorney. Me being a lawyer, one learned law. Dr. Patrick Blackshire, student Dr. Patrick Blackshire in theology and psychology. I may sound crazy, but it's that much love.
And we thank you so much for coming and bringing your beautiful pup with you. Thank you very much.
Spirit never dies. Memories never die, though we may not immediately recall. I'm sure y'all get it. I'm not on the clock for this. This is a labor of love. If y'all want to fund Foundation of Future Success Charity, 707 Sac Bank, Foundation of Future Success at Gmail, or Good Charitable Charity at Gmail. We give extensive extra credit tax deduction. Consider all your costs. If you donate $1, you have to buy some shoes to do so. Well, if you walked up to us with $1, the shoes can be tax deducted. You see? Extra credit tax deduction is available for everybody.
Thank you so much. And thank you for the work that you do. And again, for bringing your beautiful dog here today. And we are going to move to public comment. Thank you so much on the phone. So thank you so much. So we're going to move to public comment on the phone broadcast. Do we have anyone who'd like to make public comment on the phones?
Chair, your public line is open and working, but you have no callers at this time.
Okay, thank you very much. I will remind everyone we have a lot of bills coming to us in commerce and labor, including a number of housing bills as discussed, which we'll be hearing next week. That does conclude our meeting for today, and I look forward to seeing everyone at 8 a.m. Monday morning. This meeting is adjourned.